Yeah, you can yell us.
Hey everybody, we're on a tight schedule and come on in and have a seat. Kathy will give the introduction.
It's going to be a brief introduction because Bonnie did such a good job in the program and giving biographies and all of that. But I do want to say we want to thank Sue Box at the Washington Attorney General's office, since she actually is the person who put this program together. I was just the contact person between Bonnie and Sue. And I haven't seen Sue. She was supposed to be here today, but I haven't seen her yet. When we started talking about putting the program together, we threw a lot of ideas around. And at that time, Washington and Colorado were the only two states who had enacted legislation which legalized recreational marijuana. And we thought that that would be an interesting program. So I contacted Sue and said, was there anyone in their office that could speak on it? And Sue came back and says, yes, we have almost an existing panel. So I would like to introduce Jeffrey Evan, Joyce Roper, and Bruce Turcotte from the Washington Attorney General's office to speak on some of the issues that have arisen as Washington has addressed the legalization of marijuana.
Good morning. I'm going to be talking about medical marijuana and wonder whether it's the precursor for legalization as the idea of marijuana becomes normed in the community as they see the medical use of marijuana. And right now we have 20 states and the District of Columbia that have authorized medical marijuana, but the laws vary widely in the various states. So I'm going to be talking about Washington's experience. That is not going to replicate the experience of any other jurisdiction that has a medical marijuana law, because they really are widely variant. The history of Washington's experience began with a lawsuit. The gentleman you see pictured here is Ralph Seeley. Ralph was a lawyer, and before he went to law school, he was a newspaper reporter for the Tacoma News Tribune. After Ralph began practicing, and he was an avid runner, he noticed that he was having some back pain when he was running. And after going to the doctor, he discovered he had a rare form of bone cancer. And with little likelihood of succeeding with medical treatment, but he was certainly going to try. It was a very painful disease, and he tried to get into a study that was going on at the University of Washington about using medical marijuana to help deal with the side effects of chemotherapy and with the pain. Unfortunately, the study had been closed for taking any new participants. So he did what attorneys would do. He sued. And so he filed a lawsuit in Pierce County, and what he challenged the scheduling of marijuana in the state of Washington, similar to what it is in the federal law, as a Schedule I drug, which means there is no medical use for it. It is in the same category as heroin. Interestingly enough, it's not in the same category as cocaine. Cocaine is a Schedule II drug because there is a medical use for cocaine. But he challenged and said, there is some evidence that there is a medical use for marijuana, so it should not be a Schedule I drug, and he prevailed at the Superior Court level. As a result of that, the Attorney General's office took the case and asked the Supreme Court to directly review the decision from the Pierce County Superior Court. And at the Supreme Court level, that decision was reversed. During this whole scenario, as you might imagine, given Ralph's background, having been a reporter for the Tacoma News Tribune, there was a lot of press coverage about Ralph's battles with the state. And his success at first, and then his ultimate failure with the reversal of the decision. About, I think it was 6 months after Ralph passed away, maybe a little less, the voters were asked to vote on Initiative 692, which was Washington's medical marijuana initiative, and the voters approved it. It did not legalize medical marijuana. It allowed for an affirmative defense for those who possess marijuana for medical use. It had certain terms in there, things you had to meet. It had to be a terminal or debilitating medical condition. You had to have valid documentation from a physician. It didn't say prescription because physicians were concerned about DEA coming after them for their prescribing privileges if they were actually issuing prescriptions. So it used the term valid documentation, and it authorized possession of a 60-day supply without defining what a 60-day supply was. It also didn't say how they were to obtain marijuana. So there was no process, no legalization, no route for how you get it. In Initiative 692, these were the conditions that were described as terminal or debilitating conditions. They allowed for the Medical Quality Assurance Commission, which regulates physicians in the state of Washington, to add other medical conditions by allowing parties to petition the commission for the addition of conditions. At this point in time, the condition that we see most often used is the intractable pain unrelieved by standard medical treatments and medications. The Medical Quality Assurance Commission has added some conditions. This is the list of the conditions that they have added. And in 2010, they said, well, it shouldn't just be the Medical Quality Assurance Commission, but also the Osteopathic Medicine Board. So we have DOs and MDs that would collaborate to decide what should be added, and they added chronic renal failure. But they added a condition on there saying, but you have to disclose that it could impact the patient's ability to get on the transplant list. Because right now in the National Transplant Registry, if you disclose you've used marijuana, that could take you off the priority list. The Commission has denied these conditions, and they've seen some of them come back on more than one occasion. People have been asking for depression to be recognized, I think now 3 times, and they have not allowed it for these specific conditions. There was some litigation about what is a 60-day supply. And initially the legislature asked the Department of Health to adopt a rule that would define a 60-day supply. And it was an interesting time. I'm assigned to the Department of Health as their attorney, and we went around the state and conducted stakeholder hearings and heard from many, many patients and from law enforcement, from physicians, what they thought should be a 60-day supply. Ultimately, the amount you see here is what was specified in the rule adopted by the Department of Health. And in 2011, the legislature decided to take that rule, and the same amount is now in statute. So this is the amount that a medical marijuana patient may have in order to assert an affirmative defense. They have to meet all of the other conditions in the statute in order to succeed in their assertion of an affirmative defense. Some of the patients have a designated provider who assists them with their medical needs, and so they can have, if the designated provider is also a medical marijuana patient, they can possess no more than twice the amount specified here. In the initial initiative, the only people who could give the valid documentation to the patient would be a licensed physician. In 2010, the legislature expanded the healthcare professionals that could authorize medical marijuana to physician assistants, naturopaths, advanced registered nurse practitioners. This has significantly changed the climate. When it was just physicians, it was a little difficult for patients to get valid documentation. What we found when it was expanded to these other healthcare providers, we began to see the volume of documentation being offered increase substantially. We would have these events called hemp fests, where people who supported marijuana would gather at these festivals. And we began to see naturopathic physicians set up tents there. And they would be assessing people for valid documentation. And we also saw sometimes physicians, but oftentimes naturopathic physicians coming into the state and not really setting up an office, but they would set up a location to meet patients and potential patients and hand them valid documentation. So questions began to arise about, really, are they assessing the patients? Are they truly being the patient's physician, or are they just in the business of handing out valid documentation? As a result, there was an increase in complaints. We began to see where there were, because there's no age limit, so there would be 16, 17, 18-year-olds who would go to these events and get valid documentation, and we'd get complaints from parents. And about who are these naturopathic physicians, in most instances, but not always, who would be handing out valid documentation after a conversation with their minor child. In some cases, it was also adults, people who would say, how did this happen that they got these documents, and why are they now authorized to use marijuana? So we saw a volume of cases, our disciplinary cases against the licensees increase, and the Department of Health brings actions against these individuals. So in 2011, the legislature addressed this by putting in the law some indications that there is truly a patient-physician relationship. When a provider is authorizing the marijuana, they're supposed to document that they have a newly initiated or an existing relationship, and that they're actually treating the diagnosis for which they're authorizing the marijuana. And they have, in fact, conducted a physical exam, and they've informed the patient of other options and what other options they've attempted before they decided that the marijuana was the valid treatment. The 2011 legislation also authorized disciplinary action if the healthcare provider was setting up shop at the same place where the cannabis is available, developing a tying-in relationship. If their practice is solely consisted of authorizing medical use of cannabis, and if they have any kind of a kickback arrangement. It also banned the advertising of marijuana by healthcare providers. The 2011 legislation also authorized collective gardens for the first time, and this really was defined as no more than 10 patients participating in a collective and to share their supplies and resources, recognizing that some of these patients have restricted mobility, and some of them just have not been successful in trying to grow these because they can grow their own plants. And so the legislature, in recognition of that, said, well, you can have it, but it's up to just only 45 plants. So you can't multiply by 10 and have that many in your garden. And that on site is the valid documentation copy of it, so that we can verify, and law enforcement can verify, that this garden is actually was owned and, I guess, processed by these patients. It's interesting because what's happened is that this language is being used by dispensaries to say what we operate is a collective garden, and that is really not what was contemplated by the legislation. And what has happened is that in some parts of the state, because this is all locally enforced, you have law enforcement that cracks down on this and cracks down on the dispensary, and then you have other local jurisdictions that have a more laissez-faire attitude about it, and so you see the dispensaries flourish. And so this has created concerns. For example, Eastern Washington, there's more of a crackdown on these dispensaries. The inconsistency is creating some confusion among the patients and the general population. They've also put in some protections for the qualifying patients so that the parental rights or visitation time with children can't be restricted solely because one of the parents medically uses cannabis, unless they can find that use interferes with their ability to perform as a parent. It also, now this is at the state law level, so I don't know how much influence it has with the National Transplant Registry, but it said it shouldn't be the sole disqualifying factor in deciding whether a person is suitable for organ transplant. And this was put in as a result of the gentleman you see here, Timothy Guerin. He is 56 years old, as seen in this picture, and he was at the University of Washington. He was on the transplant registry and was up at the top of the list, but when it was discovered that he had used marijuana medically, he was immediately taken off the list and died shortly thereafter. Now, the patient protections are not overarching. So there's still a civil infraction. You can't display it in an open view of the public. And you have, of course, no right to ask your health insurance to cover your medical use of marijuana. And the law as written says there's no requirement to accommodate on-site medical use at any place of employment, school bus, grounds, youth center, etc., and the DUI laws apply. What's happened with the language here, it says on-site medical use. We do have a case where an employee was not using it on site, but the employer had a drug-free workplace policy and did require that there be a urine test for any drugs, and found a positive, and because she was medically using marijuana, and she was terminated. And that case went up to the Supreme Court, and there was recognition by a Supreme Court that an employer can have a requirement, a drug-free workplace, and can enforce it, and it was entirely legitimate to terminate her employment for the medical use of marijuana. So as implemented in Washington, we have had some issues because we have no state agency oversight. This is all locally enforced, and so we have seen inconsistencies in different jurisdictions depending on how tolerant or intolerant they are of marijuana use. And the 2011 legislation was really trying to bring in some state oversight, and the governor at that time vetoed a large number of sections, including the provisions for state agency oversight. And in that 2011 legislation, there was a proposal that be a registry for the patients, and it was voluntary, and those who chose to voluntarily register would be able to assert not just an affirmative defense, it'd be actually outright legal for them if they voluntarily registered. So there was an opportunity for the law enforcement to ask of the registry, is this person a medical marijuana patient, so that we would know not to arrest them, not to charge them. And that registry section was also vetoed. So among the 20 states and the District of Columbia that authorize medical use of marijuana, Washington is the only state that does not have a patient registry. And in the last session, the 2013 session, there was a proposal that the Liquor Control Board would have some oversight over medical marijuana because it was trying to reconcile our new recreational marijuana, which you will hear about soon, with our medical marijuana laws. And they came right down to the wire at the end of session, and it failed. So we expect that they're going to take that up. It's going to be one of the first bills we expect to see at the next session. So what we're dealing with right now is, as I mentioned, inconsistent law enforcement. I also hear from some medical marijuana patients about the kind of charlatans that they sometimes have to deal with. where they enter into these contractual arrangements where they're told if they pay $2,000 up front, they're going to have access to medical marijuana for the next 2 years. It turns out, of course, they take the money and then suddenly they go, oh, nope, the person who entered into that contract with you is no longer employed here at our particular medical dispensary, and you now need to be assessed again. It's going to cost another $1,500. I've been hearing from these folks that they want the Attorney General's office to do something to stop this kind of behavior, but really we don't have any enforcement authority under these contracts because it's still over an illegal substance. They want to trigger the Consumer Protection Act. They don't want to file a police complaint because they don't want to come to the attention of their local police. And every now and then I do hear about some crimes that occur where they show up where they think they're going to get medical marijuana and they are assaulted, robbed, and there have unfortunately been some instances where women have reported that they were raped when they arranged to meet somebody that they thought were going to get their medical marijuana. And some of these folks are extremely vulnerable and in desperate need of trying to access the marijuana. So, I do as much as I can when I talk with these folks about trying to report these crimes, but they're afraid of law enforcement. So, there are some who really are looking for some clarity about medical marijuana in Washington. And you have some of the folks who are taking advantage of the fact that there's no oversight that really oppose having something put in that would provide that clarity. Some of them operate in sort of a Wild West approach. And this slide needs to be updated. It's not 18. It's 20 states in the District of Columbia. And as I mentioned, there are the variations. And then this particular site has a compilation of the state laws if you wanted to see how they vary, how the different laws address medical marijuana. This is a good site for that comparison. I think these slides are going to be available so that you'd be able to access that. So if you all remember back at the time when we were all worried about the Mayan calendar, and it would just happen to be the Mayan calendar concern was just about the time we were going to be voting on our recreational marijuana initiative. As said here, this is really what the Mayan calendar was about, all of our concern. So now I'm going to turn this over to Bruce Turcott, who advises the Liquor Control Board, and he's been helping them with the implementation of our recreational marijuana initiative.
Good morning. In 2011, an initiative to the Washington legislature was filed by quite a few high-profile sponsors, which included a former U.S. attorney of Western Washington, a Seattle city attorney, and 2 former state bar presidents. And as you probably know, that passed by a 56% of the popular vote in the November 2012 general election. What I-502 did, several things, but first, within 30 days of passage, it legalized possession of limited amounts of marijuana and marijuana-infused edibles for persons 21 years and over. And these are an ounce of usable marijuana, a pound of marijuana-infused edibles in solid form, 72 ounces of marijuana-infused liquid, which actually is quite a lot, and also 7 grams of marijuana concentrates, which were added by the legislature last session. Were not an initiative. These are cumulative, so a person could have the maximum of each in each category. But the initiative did not permit home growing in Washington, unlike in Colorado, where it did specifically permit that. Consuming marijuana in public is prohibited, and the Smoking in Public Places Act already prohibited indoor smoking in public places, which includes private clubs that have employees. So the Liquor Board adopted rules to make sure their liquor licensees didn't start allowing marijuana smoking or consumption, because some of them were trying to figure out ways to do this. The Liquor Board adopted rules that prohibited their liquor licensees from allowing consumption of marijuana on liquor licensed premises, sort of closed that loophole. Driving while impaired by any substance was already illegal in Washington, but Initiative 502 added an additional basis for a conviction based on a blood test and a threshold of 5 nanograms of active THC per milliliter of blood. So a person that tests above that is per se considered impaired. There's zero tolerance for any level of THC in the blood for persons under 21. As I said, Initiative 502 did not foresee marijuana concentrates, which have become increasingly popular, and that possession and permitting the sale of them were added by the last legislature. Well, the second thing that Initiative 502 did was it mandated the state to set up a commercial licensing system for the production, processing, and retail sale of marijuana. And there's actually is no precedent for this anywhere in the world except in Colorado, which of course passed an initiative about the same time and was on somewhat of a parallel track. The year before, the Liquor Board, which is my client, had been directed by the Liquor Privatization Initiative I-1183 to divest the state liquor stores and license private sales of hard liquor. So in the following year, it was directed to promulgate unprecedented rules for licensing this 3-tier private marijuana industry. The three-member Liquor Board, which is appointed by the governor, conducted extensive public outreach with, they had 14 actually standing room only forums around the state of Washington. And they began this, receiving public comment in this way before they even started the rulemaking process, which was mandated by I-502. Now, in this 3-tier system, vertical integration is not allowed except for producers and processors. What that means is that the owner of a retail store cannot also have a production facility. Those must be separated. The business entities must be formed in Washington under Washington law, and the standalone stores may sell only marijuana edibles, concentrates, and paraphernalia, no other products, and not even their own branded t-shirts. There's a stringent gatekeeping for applicants to receive licenses. The criminal background checks are conducted by the Liquor Control Board of all members of the business entities, including every shareholder. Must all be 3-month state residents prior to the time of the application. There's an exception for marijuana possession misdemeanors within 3 years. So they recognize a lot of the applicants are going to have been involved in this area, so they carved out this limited exception just for misdemeanors. No more than 3 retail licenses are allowed per applicant. That's in the Liquor Board rules, and they actually had to reduce that to only 1 license for producers, processors, because the number of applications that were received. Now, everybody was waiting for the federal response because, well, marijuana was no longer illegal in these ways that I've described under state law. It, of course, remained illegal under the Federal Controlled Substances Act. And the question was, although there's really no debate about the federal government's ability to enforce its own laws, is the new state law preempted by federal law and valid on that basis? So the Department of Justice fairly early on said that it was going to issue guidance to the states of Washington and Colorado. And in fact, the Governor of Washington and the Attorney General visited Mr. Holder in Washington in early January, very soon after this passed, to urge the Department of Justice to give some guidance to the state. Finally, in August of 2013, after waiting most of the year, the Department of Justice issued a detailed memo, and the bottom line is that it said it will not prosecute state licensees in this new industry or seek to challenge I-502 itself if 8 federal enforcement priorities are observed. And not only that, but a strong and effective enforcement system that is actually enforced in practice is being used in the state. So what are the priorities? Well, the very first priority is preventing distribution to minors. The initiative itself has a 1,000-foot buffer for stores and other producers and processors from schools, parks, playgrounds, and other places where children might gather. They're all defined in the Liquor Board's rules. Advertising and products that would appeal to children are prohibited, and child-resistant packaging was mandated by the Liquor Board rules. And in fact, it's going to revise those rules to also require that child-resistant packaging remain child-resistant after it's opened. So in other words, it could be resealed or a cap could be put back on. The state must prevent the revenue from this industry from going to drug gangs. So the way this is addressed is criminal background checks, as I've said, are required for all applicants, their spouses, every financier who contributes funds to these new organizations. Inspections of premises are required for licensing, and audits of the books on an ongoing basis. Oh, sorry, I didn't mean to. Preventing diversion of marijuana to other states is an obvious issue. The Liquor Board has a traceability system. It's a software system that its licensees are required to use that tracks marijuana from the seedling, the clone as they call it, all the way to sale to the ultimate consumer. The board also limited the square footage, it's attempting to limit the square footage of production in the state to prevent oversupply issues, leakage into the black market, diversion. It limited the number of retail stores. It actually picked the number 334, which was the number of former state-run liquor stores around the state. No internet sales will be allowed, and home deliveries will not be allowed. The fourth priority is to prevent these from being cover operations for trafficking of other drugs. And one of the ways that this is addressed is every one of these premises, whether production, processing, or retail store, has to have a surveillance system, and that's subject to inspection by the Liquor Control Board. The final four priorities are preventing violence and use of firearms. The state law prohibits possession by patrons of Liquor Board licensed premises already. That was for bars and taverns. But it doesn't prohibit possession otherwise. It just prohibits possession by patrons. And federal law, on the other hand, prohibits possession of firearms anywhere marijuana is present. And the Liquor Board has actually advised its licensees of this federal law in the licensing process. The sixth priority is to prevent drug driving and health consequences. That's a big topic. I think those are two separate subjects that have been sort of put together into one. But as I mentioned, the per se DOI law is part of I-502. To protect the public health, the Liquor Board requires quality assurance testing by third-party labs. That the Liquor Board has had to accredit the labs itself. And so all the marijuana that's going to the retail stores has to be tested for a number of things. This is not true in the medical marijuana arena, so it's an advantage of that the recreational market has. There's a limit by Liquor Board rule on the amount of THC in edibles, and a requirement that products for consumption be scored to indicate individual serving sizes, and prominent labeling. And the I-502 contains earmarks for the taxes to go to a number of different research and education projects that are aimed at reducing usage. The seventh priority is preventing growing on public lands. The Liquor Board has authorized production on outdoor growing with 8-foot site-obscuring fences, and 30,000 square feet is actually the maximum production size that any producer will be able to. It's 30,000 square feet of canopy. The final and rather obvious priority is to prevent possession or use on federal property. So the board has, by rule, said that it will not license any activity on federal lands, and it has to observe and determine whether, for instance, land is on an Indian reservation or Indian trust lands, because those are federal lands. issue of minors, protecting minors is very important, and as I said, the 1,000-foot buffer from places where children are gathered has led to a difficult definitional task for the liquor board to define what's a playground, for example, or what's a public park. And there's some ongoing dispute over what's a park in some instances, and I think that will remain a difficult issue. The liquor board changed its method of measuring 1,000 feet to a straight line measurement to conform to the U.S. Department of Justice measurement, whereas the liquor board had been proposing to use a common path of travel. So that was one way that it, I think its rules, the rules had already been published for adoption when the federal priorities were announced, and it was good to see that I think the state liquor board had addressed these priorities and had foreseen them in its rules to just about the maximum extent possible. But this was one example where it learned of a different view of measurement by the Department of Justice, and it conformed its rules to that. There is, in the advertising arena, there is really no precedent for the constitutionality in case law of restrictions on commercial speech about marijuana for rather obvious reasons. So this is a new area. The language in the liquor board rules has been largely copied from liquor advertising statutes. And these advertising restrictions, and then the tobacco advertising restrictions related to youth, which are also used as a model, were actually the result of the Master Tobacco Settlement, where tobacco manufacturers agreed to voluntarily not to target youth, not to use cartoons and so forth. So these have now been placed into rules applying to marijuana. The liquor board did issue a media advisory that it would not enforce this 1,000-foot advertising ban against newspapers of general circulation when it was contacted by a couple of newspapers that pointed out they were actually delivered, sold near schools or delivered to the schools, and literally that would have prevented them, literal application would have prevented them from carrying any advertising for these businesses. But what does the 1,000-foot limitation mean for internet advertising? It's important to note that these advertising restrictions in the liquor board rules do not apply to everyone. They apply only to the liquor board's licensees. So the first question when there's a question about an ad, does this comply with the rules? Is this a licensee or not? And if it's not a licensee of the liquor board, there are really no state law restrictions. So this is an area, an obvious gap. It may be addressed by the legislature. In June of last year, the governor and the attorney general held a press conference to announce revised rules that the liquor board had decided to promulgate on an emergency basis, actually just before it was started to license the first stores to open in July, to prohibit products appealing to children and to actually require liquor board pre-approval of all edibles in their labeling and packaging. To date, the liquor board has approved just 42 marijuana-infused edible products, or rather as of September 30th, and it's denied, I think, about 8 or so. So there aren't a lot of requests being made yet. It's increasing over time as the processors begin to go into operation. These edibles are things like carbonated beverages, heated chips, brownies, cookies, and things like that. The sort of thing that the liquor board is disapproving are gummy bears and things that really look like the sorts of products that children typically eat. Although, as you can imagine, it's always easy to draw a line as to what is appealing to children. And I understand there's been at least one denial that's requested an administrative hearing. And so we'll start to see how this plays out through the judicial process. Security is extremely important, and as I mentioned, the traceability system, the liquor board actually requires a barcode for every plant as it goes through its life to harvest, and I believe that's zip tied on every plant. There's a 24-hour quarantine before a plant can be transported that the board is notified, so that if they need to, they could send enforcement officers to check it out. No third-party transport of marijuana is allowed, and so these producers, processors, and retailers have to do their own transportation. They're not allowed to hire security to do that for them. That's under the language of the initiative. Outdoor growing, as I've said, was added by the Liquor Control Board, and compared with indoor growing, it actually may use far less energy, because what we're hearing is that the production of marijuana indoors uses actually a tremendous amount of energy. And as I've said, under the firearms topic, the Liquor Board has notified its licensees about federal firearms law. As for enforcement of these rules, the Initiative 502 did an interesting thing, and it was codified mostly as amendments and new sections in RCW Chapter 6950, which is the State Uniform Controlled Substances Act. And and it provides that for a licensee, compliance with the Liquor Board's rules is in effect a safe harbor from being considered to be involved in criminal activity under the State Uniform Controlled Substances Act. So it actually also, the initiative also actually provides that if the Liquor Board revokes a license, all protections from criminal prosecution actually cease. The Liquor Board has limited authority enforcement officers, and it has for enforcing the liquor laws, and it now has marijuana enforcement officers. An interesting question would arise if they view unlicensed activity, if they see a grow that's not licensed by them, who has jurisdiction for that? It's really a law enforcement issue, and the Liquor Board will refer that to local law enforcement, who then have authority to take action. One feature of the initiative that, as Joyce mentioned, may have been a stumbling block for getting a medical marijuana bill passed last legislative session was that it does not earmark any revenue for local jurisdictions or for local law enforcement. The Liquor Board opened applications for only 30 days last year, and it may reopen, and probably will have to reopen this application window after it's finally finished processing the current round of applications. But it was really quite overwhelmed, and it received more applications in that 30 days than it annually receives for liquor licenses. The Liquor Board had to estimate the total marijuana usage in Washington, and it used a consultant to do this, and the number its target was 2 million square feet of plant canopy. Actually, that was the target for what it hoped to license in the initial round. The real estimate of consumption in Washington was somewhere in the neighborhood of 8 to 10 million, but the Liquor Board was hoping to reach about maybe 25% of that market in this first rollout. Well, over 5,000 applications were actually received for production and processor, and it estimated that by calling about half of them, that if it licensed all of those, there would be about 35 million square feet in production, which obviously may raise some kind of diversion issues. So it had to decide how to deal with this, decided to process only one of 3 applications that were allowed, and to reduce the square footage per license, the maximum square footage by 30%. And these square footage numbers were already in its rules. Its rules also allowed it to do this reduction if necessary. And actually that was not challenged by any of the applicants. So they're still working through, as I've said, there was a large number of applications, and they're still working through those. The 334, as I said, was the number of state-run liquor stores, and that's the number of marijuana licenses that the board has said it will issue. It did not receive any qualifying applications in 42 cities or counties. That's one reason it will need to reopen the application window in the future. It received over 2,000 retail applications, though. It needed to do something to reduce this number, because the initiative required, although the initiative did not set a cap on the number of producers, the initiative did require a cap on the number of retail stores by county according to population. So the board came up with numbers of those 334. It distributed by county and also by cities over a certain size. And then it ran a lottery. It pre-screened those 2,000 applications for age, residency, whether it was a Washington entity, criminal backgrounds, and so forth, and it eliminated a lot of them right off the bat. It put 1,170 in a lottery. These were many lotteries run for the individual jurisdictions, for the individual counties and cities, to come up with a ranking. Now the ranking wasn't like if you came out number one in the lottery, it wasn't a win, and it wasn't a guarantee of getting a license. It was only a right to have your license fully processed and to have the liquor board continue to do all the necessary background checks and review your surveillance system and your security system and everything else that is needed to comply. So the final site inspections are done by liquor board enforcement staff, and they have limited capacity, and they've also, and these are all over the state, so they send people out, but they've also found that many of these applicants are not ready, and many of the applicants don't actually want their licenses yet, but they want to wait and see how it goes in this industry, and they're holding off. So the entire licensing process is really taking longer probably than anybody expected for a number of factors. In July, the first small number of retail stores did open, only one in Seattle, and there remains only one in Seattle. There are probably 3 or 4 more coming in the Seattle area soon. But what the stores experienced, and I believe still are, is a lack of supply because the number of producers that were started back in March were limited. Now the number of producers is growing every week as the liquor board issues additional licenses. So stores have been able to open intermittently as they have supply. Of course, prices have also been high. The local jurisdictions have responded in a variety of ways to Initiative 502, and several, quite a few actually, have either banned marijuana businesses outright or imposed moratoriums. There were, and many already had existing moratoriums on medical marijuana activities. The Initiative 502 did not address local authority, did not explicitly preempt local jurisdictions from banning marijuana businesses, and so my client, the liquor board, asked the Attorney General for a formal AG opinion on this, which was issued and held that there is no preemption, and that local jurisdictions have full authority to ban or otherwise restrict in just about any way these businesses. It's an evolving area as city councils and county councils are taking this up on a daily and weekly basis. But the liquor board in response determined that its responsibility was to issue licenses without regard to the local law. And then because Initiative 502 does not authorize denying a state license based on local law. So the liquor board has to look to I-502 and its own rules for a basis for denial of a license, be able to justify that in an administrative proceeding and ultimately on judicial review. The slide says that 3 licenses have been filed by licensees against cities and counties with bans, which Jeff is going to talk about in more detail. Actually, it's more than 3 now. I believe it's 4.
It's 4 now.
Interestingly, though, one Washington city down in the Columbia Gorge formed a public development authority which applied for a license to operate a retail store, and that's pending. Public health is an extremely important issue as these retail stores have opened and as these processors begin to produce these edible products. So this is addressed in a number of ways. First, there's quality assurance testing, as I've mentioned. The Liquor Board has accredited 11 labs now, and they test for things such as mold, pesticides, or rather, no, I don't believe they are testing for pesticides. They test for THC content, and this information is supposed to be available in the stores. Some of it will be on the label, and if not, it's supposed to be available on request. THC extraction to produce these edibles is also regulated by the Liquor Board. They must use professionally certified closed loop systems. You may have seen in the news there have been quite a number of explosions caused by home extraction using butane, and that's a problem. Food safety is an issue, and the Liquor Board worked for quite a long time with the Washington Department of Agriculture, which is one of Joyce's division's clients, to come up with food rules, because what are hazardous foods that may not be infused with marijuana? Because we found out early on that the Washington Department of Agriculture and the Food and Drug Administration and the U.S. Department of Agriculture food rules were not applicable to marijuana, because foods containing it were considered an adulterated substance. So the Liquor Board was left with actually coming up with its own set of food safety rules. They're somewhat detailed, but in a nutshell, one way of thinking about it is any foods that require refrigeration or require freezing or hot holding are considered hazardous and may not be infused with marijuana, which is why you wouldn't see any refrigerated lasagnas in an I-502 store. You wouldn't see ice cream, things that required freezing. And the Liquor Board requires homogenization of the products and prominent labeling to indicate that they have a delayed effect, because there is a delayed effect, and there were some pretty prominent news stories coming out of Colorado about some very serious instances where one college student visiting from another state ate a whole cookie because he didn't feel anything. Actually, something like several servings, and then he ended up jumping off a balcony and killing himself. And there was another instance where some person killed his wife after eating marijuana-infused product. So Washington benefited from these experiences because its stores were not open yet. And so these emergency rules were created to try to address this up front. It's still being looked at. Colorado now has a working group that's proposing legislation and new rules in that state, and Washington is looking at what they're developing. One of the large unknowns and obstacles for these new businesses is banking, because deposits and any connection with the banking system or negotiable instruments is considered under federal law money laundering. This would include use of debit cards, ATMs, checks, virtually anything except cash. And this is obviously a public safety concern because cash businesses are also a potential crime target. So the states asked the federal government again for guidance on this, and they did. In February, they did issue, the Department of Justice again issued some detailed guidance with the FinCEN, the Financial Crimes Enforcement Network Agency, that imposes, that says that banking institutions may bank these new customers if they observe these heightened due diligence obligations, which are really quite onerous. They are required to file a special type of suspicious activity report, which they were already required to do for customers they think might be depositing proceeds from drug. And the banks are required to know what their customers are doing, and if their customers are complying with the Liquor Board's rules, and the banks would be required to understand the Liquor Board's rules. Now, the Liquor Board has worked with the financial industry to allow them access to its systems and to try to coordinate with them Banks are still waiting for more detailed guidance from federal regulators, and so far, as far as I'm aware, only a couple of credit unions in Washington have indicated an interest in working with this industry and trying to comply with these regulations. Finally, a challenge to the successful implementation of the I-502 recreational commercial system is medical marijuana, as Joyce has talked about, because of its unregulated nature. And in fact, the outgoing U.S. Attorney for Western Washington, Jenny Durkin, said that the current situation with regard to medical marijuana is untenable. It only carries a sales tax and not the fairly high levels of excise taxation that the I-502 product carries. Yes, even though it's illegal to sell, the state can tax an illegal substance. So,
but those jurisdictions that are choosing to be liberal are allowing them in. Some of those businesses are paying sales tax to the Department of.
In fact, one of the things the Liquor Board wanted to know before granting licenses was if this had been a medical marijuana operator, had the person been paying sales taxes to the Department of Revenue. Another pretty striking feature about medical marijuana statutes is that medical marijuana patients with an authorization from a healthcare provider are allowed to possess 24 times as much marijuana as a person, as the rest of the citizenry under Initiative 502. As Joyce mentioned, there's also no age limit for medical marijuana. So that remains a challenge for the legislature, and I think we're hopeful that they will pass something this coming session that would somehow coordinate these systems and harmonize them in some way. Finally, I just point out that Initiative 502 is codified, as I've said, at Chapter 6950, the Revised Code of Washington. The Washington State Liquor Control Board rules are at Chapter 31455, and the Liquor Board, which is liq.wa.gov, has a really excellent website, I think. It has frequently asked questions, which it's still adding to. In fact, it's just added some FAQs on advertising, and it's preparing to add another series of FAQs on advertising, so the number of questions coming in from retailers. And then you can also find the the applicants for licensures. There's a large spreadsheet under its frequently requested lists, and there are tabs at the bottom for producers, processors, retailers, and then it's sortable. So that way you can open that up and find out how many licensed stores there are, how many licensed producers are this week. Because every week they announce a few more as this is rolling out. So with that, I'm going to turn it over to Jeff Even, who's our office's expert on initiatives and the defense of initiatives. He's been very active lately in that area.
Yes, my name's Jeffrey Even. I'm a Deputy Solicitor General with the Attorney General's Office, and I'll claim the unofficial title of Election Geek Emeritus because I did elections work for about 20 years before becoming the opinions chief for the office, which is actually the role that got me into this subject. And I'm going to talk a little bit here about litigation that's ongoing in the state as we're implementing Initiative 502. But before I do that, I want to mention just very briefly how our office responded when Initiative 502 passed. We, of course, had medical marijuana for a number of years, and Joyce had been involved in that area through her clients at the Department of Health. But one of the first things that we did as an office was when it started to dawn on us that marijuana legalization for recreational purposes starts to have kind of this ripple effect out into a number of different areas of the law, we set up a task force internally to coordinate our advice. Bruce and I have co-chaired that, and we've kind of coordinated information sharing and advice but it's involved a number of other people in the office dealing with other subjects like education, higher education. We're here on a state university campus. What are the implications in that area? Employee drug testing, bar issues. The Washington State Bar Association has been dealing through, and the state Supreme Court, through its rulemaking process for implications for attorneys. There was a proposal from the King County Bar Association, for example, to adopt a new rule of professional conduct that would make it clear that it's ethical for attorneys to give advice to clients who want to be, say, licensees about what their legal options are. It looks like the course that the state bar prefers to take, and this is not entirely a done deal yet, is instead to put in a comment on existing rules that talk about the ethical responsibilities of lawyers dealing with what is still, undoubtedly, there's no question about the fact that these businesses are operating illegally so far as federal law is concerned. We can talk about preemption issues, but there is no doubt that the federal government continues to have its laws and its ability to enforce its laws. So what are the ethical considerations for attorneys? The approach that the bar prefers is to say, well, so long as the federal authorities retain their current posture, we don't see an ethical problem with attorneys giving advice to licensees. But they're recognizing, of course, that you could have a change in administrations. We will have a change in federal attorneys general. Maybe the approaches at the federal level change down the road. And so they're kind of keeping their powder dry on that end. In one of the cases that I'm going to talk about here in a little bit, one of the city attorneys actually argued to Superior Court that the Attorney General of the state of Washington, Mr. Ferguson, who was in the room at the time, I have never in 22 years in the Attorney General's office seen a sitting Attorney General appear in a trial court, but Bob appeared in this particular case, to hear the city attorney argue that he was engaging in an ongoing RICO violation and could be slapped into cuffs at any time, and that in fact one of the reasons the city had banned marijuana at the local level was that they didn't want to put their local employees into this ongoing felonious situation that those of us at the state level find ourselves. So that was kind of a bizarre moment. Anyway, so we had this task force set up to coordinate advice on these levels and kind of see, what are the interactions between different areas of practice that we're dealing with. I'll mention quickly water rights is another one. A lot of water that is made available, particularly in eastern Washington, comes from federal water projects, and federal governments have said that even if the actual, the direct supplier to somebody is a municipality or a public utility district, if they're getting the water, and similarly for electricity from Bonneville Power Administration, from federal sources, that can't be used for marijuana-related purposes. So we have all of these kind of interrelated issues going on. Now, and just to mention briefly too, I think Bruce mentioned that as retail stores are rolling out, that is something of a slow process, and we currently have only one licensed retailer in the city of Seattle. Now, you're all coming here from out of town, you're coming to a conference out of state, and what are you seeing around town? If you're seeing marijuana stores around town, unless you're seeing the one licensed retailer under Initiative 502, what you're probably seeing are the medical marijuana dispensaries that Joyce talked about. So there's these two different systems, and depending on where you are within the state, the medical dispensaries may be much more numerous and prominent than anything you're seeing licensed by Initiative 502. That's true down in downtown Olympia as well.
At one point, someone said there were more medical marijuana dispensaries in Seattle than Starbucks, but I think that was a bit of an exaggeration.
Yeah. I am going to guess you've been seeing more Starbucks. Litigation so far. Well, we've had, up to this point, 4 different categories of lawsuits filed that I'm going to talk about here. There's actually a little bit, well, 5 I think I've put on my slide. There's a little bit more that's been going on. The thing that has been taking up the bulk of my time lately has been challenges to local bans on marijuana, or excuse me, to local bans on recreational marijuana. There is also litigation going on regarding local bans to these marijuana collective gardens. And I'll talk about some of these cases specifically as I go through each of these categories. There is also a lawsuit pending in which Joyce is lead counsel, dealing with advertising by a physician. This is actually an osteopath who is advertising marijuana on his practice website and has been subject to some disciplinary action over that. We've had issues about challenges to tax collection, and challenge to, well, my final category here is I'm just calling it kind of, hey, whatever, dude. I'll talk about that later. To begin with, though, the local medical marijuana ban, this is the lawsuit that is actually the farthest along procedurally. City of Kent, which is a suburb in South King County, south of Seattle here, kind of between here and the airport, banned medical marijuana dispensaries and collective gardens at the local level a number of years ago, and was immediately sued by medical marijuana activists. There's a community of activists who care deeply, passionately about medical marijuana and who pursue litigation on, basically anything that impedes access, in their view, to medical marijuana. In this particular case, the issues were complicated by something that Joyce mentioned earlier. There was a pretty comprehensive bill passed by the legislature in 2011 dealing with medical marijuana, and which the governor extensively exercised her authority to do section vetoes. What she was trying to do, I think kind of the big picture, was veto out the state registry and things that would have state employees in the position of licensing or approving anybody's participation in medical marijuana. However, the sections weren't delineated in the bill in a way that made that really clean. Now, our governor has the authority to veto whole sections, but can't get into parts of sections of a bill. So if, say, there was one paragraph you wanted to take out, the governor can't just veto that. So that created a very complex set of statutes at the end of the day, because whole sections had been vetoed out, but other things had been left standing that made cross-references to sections that were vetoed. One of which was a provision that proposed not just to provide an affirmative defense if you were an authorized medical marijuana user, but would actually make that legal if you were on the registry. So is marijuana for medical purposes legal or illegal in this state? Yes. The Court of Appeals concluded in this case that the effect of those vetoes was that medical marijuana, except as 502 wasn't an issue in this case, except as 502 comes into the picture, it's still illegal, and the court found nothing in state law that would preempt the ability of local governments to ban these medical marijuana dispensaries at the local level. So, and there were 2 criminal cases argued the same day in which the issue had been that a search warrant was served on somebody for a marijuana grow, and the defense argued that the search warrants were invalid and therefore all the evidence resulting from them should be suppressed because in getting the search warrant, law enforcement had not proven the negative. They had not proven that the target of the search wasn't a valid medical marijuana user. They lost too because it's still an affirmative defense. The medical marijuana case with the City of Kent is actually up on a petition for review in the state Supreme Court. It was calendared to be considered yesterday as to whether the Supreme Court will take up that case. I don't know the outcome because when I left my office last night, the result of that consideration hadn't been posted to the online docket in the Supreme Court yet. So we don't know whether that issue is going up. Maybe somebody does if they have internet access here. I think somebody does. Now, local recreational bans. As Bruce mentioned, a number of cities and counties have enacted ordinances banning or imposing moratoriums at the local level on licensed recreational marijuana businesses. So these would be businesses who get or are in the process right now of applying for recreational licenses, and the city has said they take a little bit different approaches place to place. Maybe it's a moratorium, maybe it's a ban. We're not going to give you a local business license if you're one of these, or maybe it's zoning. In the case of the city of Fife, which is the one of these that is the farthest along procedurally, in the city of Fife, it's a zoning ordinance, and they've zoned marijuana businesses out of every zone in the city. So there is no place in the city of Fife in which you can comply with local zoning. So there are now lawsuits pending against the city of Fife, the city of Wenatchee, Pierce County, which is the county immediately to our south where Tacoma is, and the city of Fife is in Pierce County, and the city of Kennewick, which is one of the Tri-Cities. All four of those have active cases going against the local government brought by license applicants. Our office has intervened in all of those, so we've been embarking upon. Now, you're law librarians, you'll appreciate this. I really wanted to illustrate this slide with a picture of the Beatles from the movie. It's copyrighted. You would tell me not to do that, right? So I didn't do that. We've been doing a little travel around the state. Of these cases, though, they fall into two categories. Cases in which both state and federal issues are raised or only state law issues are raised. In the category in which both are raised, the argument kind of runs like this. Plaintiffs are license applicants who say, I can't open my business in this city because there's a local ban. The city responds that the ban is not preempted by state law, but then they say, even if we're wrong about this and the plaintiff is right and state law does preempt the local ban, federal law in turn preempts the state law. The case against the city of Fife and the one against Pierce County fall into this category, and so in those cases you get kind of a weird dynamic, a weird lineup of issues. In the Fife case, for example, we have plaintiff licensee suing the city of Kent who argues state law does preempt local law and therefore you can't have your ordinance, but federal law does not preempt state law, and so the federal law does not prohibit me from getting my license and opening my business. The city, and they are joined by interveners, the ACLU, who say basically the same thing, but in different words. The city then says, as outlined here, no, our local ban is not preempted, so state law does not preempt local law, But federal law does preempt state law, and then there's us, the Attorney General, saying, because we came to the conclusion in a formal opinion that Bruce mentioned, issued earlier this year, that state law does not preempt local bans. We side with the city as to the first part of that argument. But then when we start briefing the alternative argument that the city raises, we say, with the plaintiffs, federal law doesn't preempt state law either. So we're the ones saying no preemption anywhere. Now, in the other category of cases, the issues just kind of stop at the earlier step. The plaintiff, the case against Wenatchee, which is getting argued on summary judgment a week from today, and case against the city of Kennewick are in this category. Plaintiff says, you can't ban me, I've got a state license, your local ordinance is preempted, and the city says, no, it's not, and we're there agreeing with the city, but also basically wanting to have a place at the table in case the case goes off in some direction we don't anticipate, and we wind up with federal law issues being interjected there as well. That's a happier category of cases for us, because obviously federal preemption is kind of the elephant in the room. Now, we've had one ruling to date. It's in the Fife case. At the end of August, the Superior Court down in Pierce County ruled on summary judgment, agreed with the Attorney General and the city of Fife that state law does not preempt the local law. And so, having drawn that conclusion, the court didn't need to go any farther and address federal issues. But the judge, everybody who argued in that case, every party, got the question from the judge, if I agree with the city that there's no state preemption, does the federal issue still arise in this case? And it was clear he really, really, really wanted to rule on federal preemption. It was interesting. It was the exciting thing in the case to him. He really wanted to rule on it. So when he issued his ruling, he said, I'm actually not reaching the issue, but I will tell you all, I think there's no federal preemption here. You might find that a little surprising. I think he's actually right, because nothing in the state law precludes the federal government from going ahead and enforcing its own federal laws anyway. We don't really stand as an obstacle to the federal enforcement to the federal priorities, the federal enforcement of federal law, because as we've seen from, as illustrated by the position the federal government has taken to date, that they're going to be hands-off and let us have our experiment so long as it works out and their priorities are not threatened. So the federal government itself the federal enforcement authorities don't seem to see us as an obstacle to federal priorities. The other cases are pending, coming up on motions this fall. I mentioned there's the second one in Wenatchee a week from today. There'll be one in Kennewick in November. But we're finished now at the trial court level in the first case, MMH versus City of Fife. And so that has been appealed to our state Supreme Court. In our system, we have an intermediate appellate court, but you can appeal directly to the state Supreme Court from a trial court if you meet certain criteria. And the state Supreme Court has the discretion of whether to take that case or not. I think this is one that the Supreme Court is likely to keep, but we won't know that for some time. We're just now in early days on that. I mentioned we have litigation on physician advertising. This is Havsey versus Department of Health in a cast of thousands.
Ferguson too.
Bob Ferguson, yes, our boss is a defendant on that case. And this is a case brought by a medical, it comes up on the medical side. This is a physician who has information on his practice website about medical marijuana and what it can do for you, and he was disciplined by the State Medical Quality Assurance Commission, Osteopathic Board, excuse me, for violating the ban on advertising that's contained in the medical marijuana statutes. He has actually not taken anything down off of his website, but the enforcement of that order by the board is stayed pending litigation in court. You want
He's
to?
actually taken what was a marijuana leaf and smeared it. So now it's a green blur on top of which he puts down, he says all the information about the conditions for which you could get marijuana authorized. And he does also have a marijuana leaf on his Yellow Pages advertising if you ever go to the old phone book.
Yeah. Oh, okay.
Yeah.
So he's gone low tech as well.
Yes.
That case, the posture of this one is he sought a preliminary injunction which the Superior Court has denied, and we now have a date for summary judgment coming up in December on that one. So our court system is going to see these cases percolate up. Not true, at least as of yet, on this next one, tax collection. We have had one case. It's called Nickerson versus Inslee. Mr. Nickerson operates one of these medical marijuana dispensaries. So this is a case coming up on the medical side, although the lawyers, I think, have wanted to make it into a case about I-502. It really isn't one. Mr. Nickerson has declined to collect sales taxes. And so the Department of Revenue has administratively actually obtained a lien against him, and they're trying to collect the sales taxes on for this medical side. Now, as we've talked about, with recreational, there is a dedicated, a special marijuana tax, 25% marijuana excise tax on all three levels. But in this case, the issue is about the sales taxes, so it's general sales tax, in which his argument is, you can't make me pay the sales tax because in order to do that, I would have to admit that I have engaged in the illegal activity of selling marijuana, and that would violate my right not to incriminate myself. You can't prosecute me for any of these cases. He is, in fact, under active prosecution by state authorities up in, I think, Whatcom and Skagit counties to our north. So he actually does have pending criminal cases going for him. He brought this case in federal court. The federal judge dismissed it very quickly on jurisdictional grounds under the Tax Injunction Act. You can't go in, federal courts do not have jurisdiction to grant injunctive relief against a state collecting state taxes. So that it's a jurisdictional bar. But in the course of the argument on that case, the federal judge, so this point came, I love the fact that it came from the federal judge, not from us. The federal judge who asked the plaintiff's attorney, when faced with the argument of, they can't tax this, it's illegal, said, isn't that how they got Al Capone? Yeah, it is. But we weren't going to play the Al Capone card. So there's been that case. That has not reared its head again. I frankly expected that when the federal court dismissed that one, it'd get refiled in state court, and it hasn't, at least to date. So that's an issue that's kind of hanging out there. And then, well, whatever. I've actually had to learn how to practice in the United States District Court for the District of Columbia because of marijuana litigation. By the way, it turns out they're the one jurisdiction I've encountered in the country that if they say, hey, if you're a lawyer for the state, all you got to do is identify yourself to us, and we will let you practice in our jurisdiction. It's an interesting little jurisdictional tidbit, because I guess in the District of Columbia, they're used to seeing government entities get sued, and they don't want to fuss about a whole bunch of pro hoc vici motions. In this particular case, we have a frequent pro se litigant. I think probably everybody in state government and some local governments knows this guy for about 2 decades worth of. I remember the case 20 years ago when he was arrested wearing a leopard suit in a tree in Olympia, and was engaged in civil disobedience over spraying malathion, I think, for mosquitoes. He sued the governor, the chair of the Liquor Control Board, the federal attorney general, Eric Holder, and the federal officials who had anything to do with the memo that Bruce mentioned, talking about what state preemption or what the federal posture would be toward Washington and Colorado. We got the state parties dismissed out of that case for lack of personal jurisdiction because, hey, you want to sue us? Here we are. Come here. Well, this particular pro se litigant has an order in effect from the federal district court here in the Western District of Washington saying that he can't file any lawsuits in this jurisdiction because he's filed so damn many stupid ones unless he comes in and gets court approval first. So he couldn't sue here without getting that court approval. That's why he went to D.C. We got the case thrown out on that grounds. And by the way, when I put in my motion to dismiss a copy of the federal court order from this jurisdiction that explains why the heck it is we're back in that jurisdiction, the result was he filed a bar complaint against me because, my God, how can I give a court an actual true and correct copy of a court order? That's terrible. His underlying theory in that case has to do with violations of the National Environmental Protection Act. That is, he says that before the U.S. Attorney General issued their memo to Washington and Colorado, they should have done an environmental impact analysis and seen that issuing this memo was going to have a terrible environmental effect in the states, and we can't do that. And he alleges that the memo essentially took over the state programs by the federal government because they enunciated what these federal priorities were. And so, yeah, there's a motion to dismiss by the federal defendants pending now in that case. That's it. Sure. If anybody asks, by the way, where is the legal licensed store in Seattle, we might have to call and see if your office back home has employee drug testing.
Hi. Well, where to begin? Just watching the way legalization has played out is definitely appropriately mind-blowing. Even for those of us who haven't inhaled. So what I'm wondering is, when do you see the dust settling sooner or later on this management of marijuana, and how much will it or will it not borrow from the way we manage alcohol and tobacco?
Well, let's see. I'll maybe take a first shot. First of all, it does borrow quite a bit from alcohol in particular. When you look at the text of Initiative 502 and then compare that to the existing liquor statutes, you can really see that they were looking at the liquor statutes as they were drafting the initiative. So there is something there. I think as to when the dust is going to settle, it kind of depends on a number of developments. Obviously, the big thing would be what's the federal position, and does federal law change? I'm not assuming that's going to happen anytime soon, but that would be a big variable behind all of this. Second thing is, when you look at those federal priorities and the objectives that they're looking to from enforcement of their own federal laws, and you look at the objectives that the state sets out in the recreational marijuana statute, it really becomes a linchpin that medical and recreational get integrated. because if they stay out there as two completely separate marketplaces in which one is taxed and one is not, one is regulated and one is not, the regulated market doesn't really have an even playing field to play on. So that's a big deal. And the state preemption issues that we've talked about, all the lawsuits that we're dealing with cities right now could be resolved statutorily if the legislature said either that state law either does or doesn't preempt local jurisdictions from imposing their own bans. And as that gets resolved, that has a lot of impact on how the legal market can permeate and displace the black market.
And from my perspective, what happens legislatively with the consolidation or reconciliation bill in this next session will be a major indicator of whether we're going to have another flurry of lawsuits and challenges, or if they can reconcile in a way where people are feeling like, okay, we can live with this.
Mm-hmm. Yeah, and I think the underlying legal uncertainty, which plays into a lot of practical issues that arise, will never really go away until the federal government changes, until federal law is changed, and which may be a long ways off. But meanwhile, states are taking up initiatives. Alaska and Oregon have initiatives on their ballots next month, and other state, there may be plans that are afoot in other states, and so it's probably maybe a matter of time. As far as Initiative 502's goal of displacing the illegal market in Washington, I think that's going to take quite a bit of time. There's so many uncertainties as we've talked about, and it's not really clear how easily that's going to happen. And the price difference is really quite a large issue. The Liquor Board is actually directed by the initiative to report back to the legislature, I think every 3 years, on recommendations on the taxing structure.
Thank you.
Any other questions?
I just had a question on the implanted food in terms of how's that going to work on product liability in terms of dosing. Do you you're just hiding it behind the alcohol exemptions in terms of we don't know what the effect will be based on how much you can consume, because that's a pretty complex analysis based on body weight and personal chemistry. And so I was just curious how you prevent a product liability regime, or if you just have exempted it by making it a hazardous substance and say, look, there is, eat at your own risk, and if you eat too much and jump off a bridge, that happens.
I think I think that is quite a risk for these businesses. One of the things that the Liquor Board required in its rules is that they do carry a $1 million liability policy, name the state, by the way, as an additional insured. But we'll see. It's something that I think the state is going to continue to look at carefully. And I've heard that there may even be legislative proposals to ban edibles altogether. So we'll see how it plays out. Hopefully there aren't horrible stories in the news about bad things happening. The latest thing, it was kind of funny actually, but could have been dangerous, was exploding pop bottles in a store in Bellingham that were over-carbonated. And but fortunately, it sounds like the processors has agreed to take them all back. But if they hadn't, what would the Liquor Board have done? What would their authority have been? It turns out that the FDA has recall authority. So that's another federal disconnect. They're not going to act. So the Liquor Board may have had to try to use its existing rules, or even consider making new rules to cover that sort of situation.
Any other questions?
Thanks. Wonderful subject. Really great example of the living law. It's the most exciting development in law I've heard in a long time, just because of the amount of litigation. You mentioned that the control board has access to the security cameras. And I was wondering if you could go into a little more detail about that. Can they view it? Can they just walk in with no threshold whatsoever, seize the tapes? Interagency concerns? What limitations? Any litigation on that issue?
Well, yeah, they prescribed fairly detailed rules about what the surveillance system is to consist of. They tried to go into the technical specifications without getting so technical that, they were like there were unintended consequences. But they're to preserve the tapes for a certain period of time, and I don't remember the length of time, but and to be accessible by the board, they would have to, obtain them. They don't have a way at their headquarters to be watching as well. But this is I guess under search and seizure law, I would think this is a heavily regulated industry, if any is. So hopefully they will have the authority they claim in their rules to enter at any time.
We have had a few cases where regulated healthcare practitioners have tried to challenge the ability of the Department of Health and the boards and commissions and inspectors and investigators to obtain healthcare records for them to be able to ascertain whether care is being delivered safely. And we've been able to prevail in every one of those legal challenges because of the need to really be out there protecting the public and the healthcare that's being delivered. And they are in a regulated industry.
So I have a not very substantive question, but recently the green Red Cross, that's now not a Red Cross, but a Green Cross, has popped up everywhere, I think, where there are medical marijuana dispensaries. Is that correct?
Yes.
Will that be used with the recreational marijuana places as well, or is there some? I was just curious whether there was.
Yeah, that's a really good question. And actually, so early on, the liquor board debated whether to have some sort of required logo or mark that would identify that something is marijuana. And they came up with a mock-up that they put in their initial round of proposed rules. That was the silhouette of the state of Washington with a marijuana leaf in the middle. And I thought it looked really cool, but the governor didn't like it, I understand. So they took that out of their rules, and I think that now says that they may, they may require some sort of logo, but there hasn't been any more work done on that. But I do hear from Colorado that they are working on one, or they may already have something like that in Colorado, and that it may be like an impression on a product. But it seems like a good idea. So it's current. There isn't any particular sort of mark.
Well, I think the other thing is if you drive around in the state of Washington in different places, and just in the most recent 2 or 3 months, you can come upon 3 or 4 of those signs in a very small area. Yeah. Mm-hmm. Yeah, and it's really it's really changed.
Well, the retail stores are only allowed under the initiative to have one sign on the premises, 1,600 square inch maximum, and with their name on it. And so now we're getting a lot of questions about, can they include other things on it? And basically the liquor board is saying no. So I haven't seen any of these signs yet, but I'm not sure if you'll be able to tell what kind of store it is.
These are
depending on their name.
These
Yeah,
are medical
that
marijuana
would be
dispensaries. Yeah, they're
Green
problem.
Cross,
They are increasing in number, and I don't know if it's a flurry before, in anticipation that something's going to happen.
There's no limit on the number.
And they're not legal. And again, it all depends on local law enforcement. And I will tell you that Seattle-King County has been traditionally the most liberal. And if you go into eastern Washington, you will not see as many of these. And the people who try to set them up over there, sometimes they're really perplexed that they can come over here and they see law enforcement driving by all the time, these signs, and ignoring them. And yet over there, some of them will even call the local law enforcement and say, here are my plans, thinking that they're going to work cooperatively. And next thing they know, they're being arrested. And it's because it's entirely dependent on local law enforcement discretion.
And in contrast to that, when I drive to work through downtown Olympia, I pass 2 of these medical marijuana dispensaries every morning, and I come within a block of a third. So
Yeah, and I drive by, there's a tavern, across from there is a green cross, and next to that is a bakery. So I figure, you know, that community right there takes care of you, you know, you get yourself a bit of drink, go over there, yeah, just, you don't have to get in a car, just walk.
Yeah,
There you
just
go.
just
Get
have the
your
right
needs met.
documentation,
Get
right?
your needs met right there.
Great. Well, thank you so much. This is really. So lunch is going to be served in the law library. So you'll go back to the entrance, toward the entrance you came in, and go down the elevator or stairs, and there'll be some folks to help you. There are a couple of different buffet areas, and we'll have our business meeting, and then be back in here at 1:30. It's not, it will not be locked.
Literature inside. This is the bag. This is
Well, it's being given out to all. You pick up some.
If you pick up something on the attendees or
Yes, yes, and then here, it's something that's being I can have some, like all these bags I get at these various conferences. No, they've all adopted it. They've all adopted it, and it's a, yeah, it's a way. It's a interesting word. Yeah, they used it so that people will be. It's standardized. And, yeah.
yeah, they don't belong to something or to use it.
No, they're all starting to use it. Yeah. It's an informal trade thing.
There's another one.
Oh yeah, you're right. So that's open already.
Yeah.
Go to a church, I think.
Yeah, that's the
Oh
one.
yeah, there was.
So
there were the
they've already
protests.
opened?
Yeah.
Yeah, and
Right.
then there are a couple up on Aurora Avenue that might be opening.
Well, that's not. I had my vitamin one. So shall we go down to the library and get our lunch?
You may get hit with more questions at lunch.
Yeah.
Thank you so much. Yeah, I was looking at it.
I need to go find out. You're also what? You're not kind of running the show.
We just launched. Yeah, we just launched. I just give out. So they're all sitting. They are really nice. Yeah.
I got to because I brought my stuff to church. I just, you know, I wouldn't leave it.
All right, good luck.
So the cable is the least of the problem.
Remember that, and I also had the same thought each time you had it.
Yeah, well, and
Yeah.
here's a demonstration. Okay, sure. All right, good, great.
Be trying to find you.
Yeah, otherwise I would have just had time a little bit of time.
And that, I think that's just complex.
Okay.
We'll come back right away. Thank you.
Yeah, yeah, and then you've got it all lined up, and then you put out just right.
This is like a band.
Finally all be. Well, that was really interesting.
I didn't realize that, the medical marijuana facilities were illegal.
I didn't either. Because I'd seen the signs. I
Well, and they
assumed
are
were okay.
all over.
Yes, and they are.
You know, come up and down Lake City Way, that's where I see it
Lord,
most.
yeah, that's right. And I was just, yeah, and some, honestly, I saw them like 3/4 of the place that was big, right?
She's like, I want to buy an iPad myself.
Yeah, the bad laws feel like, bring it.
Sort of, I have some ads this year, so it's, whereas my kids, my wife's much better. I need to get more, and I do have a bunch of those.
Oh, I didn't bring those.
But it's the problem when I lose those. I lose pens all the time.
Oh, these aren't the pens anyway. I was already at a conference earlier this week. I was at home, and we had the.
Oh, you were in Chicago.
Oh, I won't. I'm not going to. Yeah. Mhm. Mhm. Right. Okay. 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 I did. I sent them a note. Yeah, I did. I said that we want to meet on the renewal, you know, so. Mhm. Yeah, I have worked on them, and I'll tell you what I've done in my downtime even today. I'll send you over Schwabies. I'll get them done. I'll get them completed over the weekend and get it to you on Monday at the very latest. If I don't even get it done tonight, you know what I mean? So, okay. And I don't, you know, Eric, you know what? I'm not contentious. You know what? It bothers me to even get contentious. You know what I mean? Right. Yeah. Yeah. No. Oh, absolutely, absolutely. And I will do what you asked me to. No, I think I get, you know, I think here's the thing that I've kind of figured out. Two things. I think I take the female attitude, like, you know what I mean? I'm like, even with Sean today, you know what I mean? I did everything this morning. He didn't show up until 9 o'clock. Okay? And right, exactly. And I think, you know what? He's telling me everything to do, and I'm thinking, you know what? Take it as, you know, stand up for yourself, Terry. Same with Josie. Sometimes I think, you know, I take that whole driving in the car thing. I look back on it. I'm going to change my ways, and I'm going to say to him, you know what, Josie? Here's what I've done. Tell me what you're doing. You know, I feel like sometimes I'm chasing Paul around. I feel a little better chasing Paul or Kevin around only because, like I said, they live in a whole different country. You know, but even then I get a little pissed. Look at it. I've teed up Miller Nash. I have teed up Stoll. Paul, what are you doing? You know, where are you at? Are you in contact with them? Are you working them too? Because I thought the deal was that, hey, if we teed up something, we can count on you to continue to do the massaging. You know, not that I disappear, because I don't. I mean, I'll double up, you know, on when I talked to Miller Nash, I copied Paul. Paul jumped in on the conversation. Then the three of us were emailing with, you know, the librarian there. I have no problem with that. I'm not going to walk away. I want the business more than anybody, so I'm not expecting somebody to do my heavy lifting. But with Josie, on the other hand, I just kind of feel like, really, dude? Come on, I just set up a bunch of accounts for you. What came of them? You know? I do too. Couldn't agree more. Right. Right. But my question I ask of Joyce in particular, you know, is one thing. If I've teed up 3 accounts and all the other reps have teed up 3 accounts, what are you doing to make them happen? Right. Right. And the same with Eric, and the same with Paul, and the same with Kevin. They should be communicating. I should not have to run Kevin down so hard. I really shouldn't. And I think, you know what, from a girl that's been here now a year, I feel like they're all very protected. You know, well, guess what? Bullshit. I get you're working. We're all working. Do you want the business? I want the business. Let's just make it happen. You know, you're not sitting on the counter puff, and I'm going to do all the heavy lifting. It's going to take both of us to drive the business home. I have seen it happen. I know it can. But you got to work together, and you got to work it right, and you have to communicate. And that, okay, if let's say you don't like shoot emails to me or copy me on your conversations with the whoever you're having the conversations with, then load the information into Salesforce so that I can see it. I prefer it don't. We're grown. Yeah. Yeah, and you know what? I know the whole thing, you know, the management, the team, I get it, you know. And I'll take my lashing, like I told you earlier, I'll accept the team, and I'll own that, I'll change my ways. And the rest of it, you know what? Goddamn. You know, Kevin, give me, take a number, put $7 grand in there if that's, you know what I mean? Don't make, I chased it down for days to get something out of it.
just use it.